Enough. Okay. Welcome to our August 26, 2025 Code Enforcement Board hearing. If there's anyone who wishes to speak at today's proceedings, please stand and raise your right hand. You must be sworn in to give testimony. Do you swear and affirm to tell the truth at today's proceedings? Thank you. You all may be seated. At this time, I'll allow the board to introduce themselves.
Good morning, everyone. I'm Jackie Shaw.
Good morning, Ed Murphy.
Good morning, ladies and gentlemen. My name is Terry Nolan. I'm the chairman of the committee.
Don McCarney, Vice Chair.
Alex Schneider.
Kimberly Smith, panel attorney.
Did you want to say anything else?
Yes.
Turn
So we here are volunteers. I think I've never done this before. We're volunteers here, so we're just doing our service for the community. If any of you would like to do an equally lovely job like this, you just approach your commissioner. Let's go.
Okay, thank you. Our first case is on page 1. Senior Inspector Alexander Boris, property address 2223 Northwest 9th Court, case number BE 25020178, owner Manuel J. Galu Gutierrez. Notice posted at the property on 7/17/25. Notice posted at 1 Eastboro Boulevard on 8/12/25.
Good morning, Board. Alexander Alvarez, Building Inspector for the city, presenting case number and address as read. The property was cited for violation of Florida Building Code 2023, Section 105.1, work without permits for interior alteration, including but not limited to a new bathroom west side of the building adjacent to Florida room and a new kitchenette sink adjacent to illegal bathroom. Permits have been applied for and are currently under review. The owner is here today to speak. Go ahead.
Hi, good morning. When I bought the property, I was Manuel Gutierrez. I'm the owner of the property. I recently, this year, purchased the property. Actually, the picture you see in the screens are from the listing. The bathroom and the kitchenette, or the wet bar, was added by the previous owner. I did not knew that was without permit. The inspector came, informed me. I submitted last week the blueprints, the application, everything. Yesterday they told me they needed to fix something on the application, and I did. And I believe the inspector told me that we're going to ask for an extension, so the city can review everything and hopefully approve it and be in compliance. Thank you.
We're asking the board. We're asking for the board to find the violation exists and to grant the property owner 154 days to come into compliance or a fine of $50 per day thereafter.
Inspector, question. What's the course of action to resolve this problem? Is it going to be a demolition, or can he get
permit? He's already submitted. That is an existing family room. The family room, it's not in violation per se. The bathroom and the kitchenette were installed without a permit.
But will the city allow that at the end of the day?
Well,
with the permits, proper
from a
permits being
building
pulled?
perspective, yes, it's going to go through other disciplines. Now his plans, there's going to be other disciplines that are going to be looking at it. I can't speak for those other disciplines. As far as this is all connected, it's part of the house.
Yeah.
It's not like it's a separate dwelling unit, on the side of the house or anything like that.
Okay. So it is possible. what he's
Very
doing.
possible.
Okay.
Very possible.
Thank you.
Yeah.
I move that we find for the city and the violations exist as alleged, and that we order the property owners to come into compliance by January 27th, 2026, or a fine of $50 per day per violation will be imposed and recorded.
Any opposed? We'll see you in January.
Thank you.
Thank you.
Our next two cases, Inspector Andrew Gebbia. The first one's on page 5, property address 2720 Southwest 18th Street. Case number BE 25050057. Owner FKH SFR C1 LP in care of First Key Homes LLC. Notice posted at the property on 7/15/25. Notice posted at 1 East Run Boulevard on 8/12/25. This is a new business case.
We'll wait for the inspector to go first.
One moment, please. Please hold.
Good morning. Andrew Gebbia, building inspector for the city, presenting case and address as read. This property was cited for violation under section 47-19.13. D2, City Muni Code, seawall in disrepair. The seawall at this property is in disrepair. All property owners must maintain their seawalls in good repair. A seawall is presumed to be in disrepair if it allows for upland erosion, transfer of material through the seawall, or allows tidal waters to flow unimpeded through the seawall to adjacent properties or the public right-of-way. This case was opened on 5/9/2025. The IR was mailed on 5/13/2025. Code board hearing was scheduled on 6/17/2025. Using the photos provided from Code Inspector Ramon Oliveri, I was able to see that the seawall at this property is in serious disrepair. The seawall looks like it's about to collapse into the canal. I've had no contacts with the owner until recently. This is their attorney right here. The city's requesting the Code Enforcement Board to find that the violations exist and to grant the property owner 154 days to come into compliance, or a $50 a day thereafter. I will allow the respondent to speak.
Good morning, everyone. Good morning, Virginia Costa on behalf of the owners. The property is being sold as is. I did speak with Inspector Gebbia, and we find that 154-day extension to cure the issues is reasonable, and we hope to have sold the property before then.
Oh, you hope to have the property sold?
Yes,
So that's not going to cure anything. You're just giving someone else a bag of crap. I mean, I don't understand that.
Well, I understand that they are.
Turn the microphone on, please.
I understand that they are in the process of they have to make repairs in order to be able to sell the property in a reasonable value, which is what they want, their return of investment. And so I understand that they have spoken with Inspector Gebbia and they're working on that. And in the meantime, they do have the property for sale.
Well, you understand it's going to cloud the title, right?
Absolutely.
Okay.
Absolutely, yes.
And you're going to disclose this to whoever buys the property,
Absolutely, of course,
right?
yes.
I got a question, Inspector.
Sure.
I noticed that this is a very different building code, 4719.13. Explain. This sounds more like a municipal code violation.
Because it is a municipal code violation.
It is?
Yeah.
So
Muni Code, City Muni Code.
Why are we dealing with it instead of code enforcement?
Well, Code Enforcement has a case on it as well, and they felt that this was a little more in the arena of building, so it got transferred to me.
Okay, so it falls under our realm regardless, correct?
Mm-hmm.
Okay, thank you.
Sure.
Yeah, I move that we find for the city and the violation exists as alleged, and that we order the property owners to come into compliance by January 27th, 2026, or a fine of $50 per day per violation will be imposed and recorded.
I'll second Ed Murphy.
All of those in favor say aye.
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 Any opposed? You're good.
Thanks, everyone.
Our next case is on page 6. Inspector Andrew Gebbia. Property address 2855 West Commercial Boulevard. Owner, Lauderdale Commercial Boulevard Partners, LLC. Case number BE 2504-0071. This case was first heard on 5/27/2025 to comply by 6/11/2025. One section at $1,000 per day. Order recorded, complied. Total accrued fine, $70,000. Notice posted at the property on 8/5/2025. Notice posted at 1 East Royal Boulevard on 8/12/2025.
Andrew Gebbia, building inspector for the city, presenting case and address is read. This case is complied. The city is requesting fines to be reduced to the administrative costs. I will allow the respondent to speak.
Microphone.
Is that better? Good morning. Sydney Satz, attorney on behalf of the property owner. We have been working very diligently to address these violations, this one violation. It was initially understood that a structural permit was going to be required for the scope of work. There were issues regarding the splits at the property, the AC splits, amongst other things. We found that those items were in fact permitted dating back to the early 2000s. We arranged and attended an inspection with the city to actually visit and look at these units. It's 12 units in total. And I think we all agreed at the end of the day that the work that was done did not require the extensive permitting that we had initially understood. The only two permits that were required to bring this property into compliance were an electrical permit and a plumbing permit. We worked as quickly as possible to pull those permits. We have been in constant contact with the city, and we appreciate the city's recommendation today.
I move that we reduce the fine by $10.
Second.
These were the people that postponed from last time, from the last meeting. Did you ask for an extra 30 days last time? Did you postpone the meeting?
We did. We requested a brief continuance.
Can you hear me? Yeah.
Yes, I can. We requested a brief continuance. Myself and the other lead attorney on this case were in trial. The board did grant that continuance, and we continued to make efforts to bring the property into compliance during that time.
Okay, so $30,000 of this fine is from that postponement. Is that correct? Anyone?
Well, I mean, they choose to continue the case here. I mean, I don't see how it's our problem. Just to clarify, correct me if I'm wrong, that once we grant someone a fine reduction, they cannot contest it in the future, correct?
So, I'm over here, sorry. For the record, Ronald Montoya Hassan with the City Attorney's Office. If there is a fine reduction at either magistrate or code board hearing, then they aren't allowed a further reduction through lien reduction. The lien amnesty process, because that's, sort of double dipping. I also just wanted to add for the record, this is old business. It was coming back. It's not noticed as a Massey, so if council is willing to waive additional notice for an additional hearing for a Massey, then we can resolve the issue of the fines and costs today. Otherwise, it would have to be set at another hearing with notice as a hearing to impose fines.
Okay. Would you mind giving me just one moment to discuss briefly with my client?
Okay.
Okay, we'll call another case in the meantime. This will be continued. Our next case is on page 6. Senior Inspector Jose Saragusi, property address 1304 Northeast 16th Terrace. Owner Martin Quinnett. Case number BE 25010172. This case was first heard on 7/22/25 to comply by 8/26/25. One section at $50 per day. Order recorded, not complied. Notice posted at the property on 8/4/2025. Posted at 1 East Royal Boulevard on 8/12/2025.
Are they here?
Is there a respondent here for 1304 Northeast 16th Terrace? Oh, please. Oh, so you don't want to say anything?
Oh, no, I don't know if I have to.
Okay. Well, if you do, I will have to swear you in. Okay. Are you Martin Quinnett? Yeah. Okay. Go ahead, Jose.
Good morning, Inspector Saragusti. On behalf of the city, presenting the case as read. The case is not complied. I will let the respondent to speak.
I will take it to. Just press the button there. There you go.
The case is for duplex converted in triplex, and he will explain the situation.
How far back do I go?
Tell
All
us
the
your
way.
name.
I mean, I rented. Owner.
Owner.
Okay. I rented for like 5 to 10 years, and it was always a triplex. And then I bought it. And then this happened recently, and I bought it in like 97. And this is the first I heard of it. But with Joe, or I keep calling him Joe, Jose, he said I needed to put the door back between the two units. So I'm in the process of doing that.
Okay.
How much time do you think you're going to need?
Huh?
How much time do you think you're going to need to get that done?
Well, I put the door in myself. It's there, but it's not complete. You got to put the trim and everything, but I'm going to have somebody else do that part, and he says he can do it on Monday.
Okay.
Were you here last month?
I screwed up. I thought it was Thursday the 26th, so I got ready to go, and then I looked at the paper, and I said, oh, boy, I missed it.
So, Inspector,
the city doesn't oppose to 79 days extension and stop the fines.
and as he said, all they have to do is just replace a door.
Yes, correct. They need to have a connection in between one unit with the other one in order to be only two units or not three. For that, and the next hearing will be the November 13. For that one, we request the 79 days. It will be complied maybe next week, but anyway.
Are there any other tenants or anything? Are there any other tenants?
Yeah.
Yeah, and like 3 different units or 2 units?
There's tenants in 3 units, yeah. I mean, I live in one of them.
I'll move for the 79-day extension.
Second, Ed Murphy.
The city agree with 79-day extension, correct?
All those in favor, say aye.
Aye.
Aye. Any opposed? You have 79 days.
Thank you.
Hopefully we will see you.
Thank you. Should I shut it off?
Now leave it on.
You leave it on.
Our next case is on page 2. It's a new business case. Senior Inspector Preston Mark, property address 620 Southwest 18th Street. Owner Lawrence A. Martinal III. Case number BE 25050034. Notice posted at the property on 7/15/25. Posted at 1 Eastboro Boulevard on 8/12/25.
Preston Mark, Building Inspector for the city, presenting case and
I'm sorry,
address is
Preston.
read.
Jose, thank you.
Preston Mark, Building Inspector of the city, presenting case and address is read. This property was cited under violation Florida Building Code 2023-105.1, work illegally performed without obtaining the required permits in the following manner, but not limited to the replacement of soffit, truss work, girders, without the required permits. This case was opened 5/7/2025, inspection report mailed 5/8/2025, and court board notice mailed 6/17/2025. We visited this property to investigate a complaint. As noted, during our investigation, we observed that work was done, including work on the soffit, replacement, truss work, and the installation of girders and columns. I spoke with the owner, Ms. Lawrence, who indicated that the roofing company was involved with doing a re-roof on his home, at which time they found that there was some rotted wood, which they replaced without permits. I explained that the permits are needed, and as a result, we issued a stop work order at that time. The respondent is here to speak.
Lawrence Marneau, property owner. I was having my roof redone, and as the roof was being redone, they found extensive termite damage, in which the roofing company proceeded to tell me that they would be happy to repair as necessary. They went ahead and started to proceed. I guess it was when they were getting their sheathing inspection for the roof that the inspector noticed that particular replacement. I was then informed and did have a conversation with Mr. Preston about the situation. Informed my roofing contractor, who has subsequently submitted the application for the structural permit for the replacement of these, for the beams. The replacements were for as is, and some additional information was required. We provided a letter from the structural engineer with the angles that were now installed with this to comply with the uplift requirements. It is still currently under review because we submitted that as part of our roofing permit. After speaking with Mr. Preston again, he said we had to submit a structural permit. We submitted that on, I believe, July 15th. We've had a couple of comments since then, just more administrative stuff than anything else. And we're hoping to obtain that permit within the next couple of weeks and immediately call for our inspections to have it resolved.
The city is requesting that the board find the violations exist and grant the property owner 79 days to come in compliance or fine of $50 a day thereafter.
Question, how was this complaint discovered? How did it get in the city's radar?
Field inspector.
Field inspector? Just ran for the roof?
The roofing inspector.
Okay, so he just did a routine roof and saw there was more than meets the eye to it?
Exactly.
All right, thanks.
Yeah, I move that we find for the city and the violation exists as alleged, and that we order their property owners to come into compliance by January 27, 2026, or a fine of $50 per day per violation will be imposed and recorded.
I do have one question.
Oh, yeah.
When I purchased this house back in '97, I had a similar after-the-fact permit issue that I was asked to resolve. Once I get this resolved, how do I confirm that if this has been removed from the city's situation? Because in that case, 5 years later, I had a refinancing to do an extension, and I found a $75,000 lien on my house from the city on an issue that I did comply with. I do not wish to go through this again. So how do I confirm that once I have satisfied Mr. Preston and the city's requirements that I have this off the agenda?
I will submit some documentation to you confirming that the case has been closed.
Thank you. I appreciate that. Thank you very much.
Wait 1 second. Yeah, motion.
Who seconded? No.
I'll second that motion.
All those in favor say aye.
Aye.
Any opposed?
Thank you very much.
Our next case is on page 3. Inspector Andrew Gebbia, property address 1432 Southwest 26th Ave. Case number BE 2504-0072. Owner Juan C. Jimenez, Isabel Moline. Notice posted at the property on 7/15/25. Notice posted at 1 East Royal Boulevard on 8/12/2025. They left? Did they leave? Oh, so he left? Okay. Okay, we'll do it at the end. Yeah, okay, thank you. Okay, the respondents left, so we won't hear that one now. 14, I'm sorry, do I have someone here for 905 Southwest 22nd Terrace? Okay. Page 3, property address 905 Southwest 22nd Terrace. Owner, Lonnie Saunders. Lonnie Saunders Revocable Trust. Case number BE 2506-01. Saunders on 7/14/2025. Notice posted at 1 Eastboro Boulevard on 8/12/2025. Senior Inspector Preston Mark.
Preston Mark, Bill Inspector of the City, presenting case and address as read. This property was cited for violation under Florida Building Code 2023-105.1, work illegally performed without obtaining the required permits in the following manner, but not limited to: the illegal conversion of a utility structure into a livable space that's currently being rented. Second violation, 116.1.1, building or structure that, in the opinion of the building official, has become unsafe or which has been substantially damaged or otherwise shall be deemed unsafe. Building and permits shall be obtained to either demolish the structure or bring the building in compliance with the applicable codes. This case was opened 6/12/2025. Inspection report mailed 6/17/2025, and code bond notice mailed 6/17/2025. I visited this property to investigate the possible illegal conversion of this unit, and I was assisted by Detective Hayes and Detective Blunt. We met with the owner, Lonnie Saunders, who gave us access to review the structure or inspect the structure at the back of his home. During our inspection, we spoke with the tenant of this space, Mr. David Prince, who's also the complainant. He indicated that when he rented the space, he was not advised that it was illegal. We explained to the owner and the tenant that this structure will be deemed unsafe and would require a permit to convert it or demolish it. The owner informed us that he would like to the owner informed us that the tenant has refused to vacate the premises, and he is in the process of pursuing a legal case against him. The city is requesting that the board find that the violations exist and grant the property owner 154 days to come in compliance or a fine of $50 a day thereafter. The respondent is here to speak.
Thank you. Yes, I have since gotten the tenants.
Please. You're on. Just
Okay.
state your name.
Oh, I'm sorry. My name is Lonnie Saunders. I'm the owner of the property. I have since removed the tenant. He's gone now. As far as the minor code violations, I've already corrected those. As far as the zoning issue, I've hired an attorney to help me with that. He's going to be in touch with the zoning department. It may end up with a variance hearing. So I appreciate the extra time.
What's the recommendation?
Well, all these pictures, that's all in the back structure, correct?
Yes.
All these pictures are the ones in question, right? Nothing on the main house.
Yes, the structure in question is at the back, with circle there. City is requesting that the board find that violations exist and grant the property 154 days to come in compliance or fine of $50 a day thereafter.
Wait, so you said that the code violations have been handled? Is that
There
accurate?
were minor violations. Yeah, the pipe under the sink was dripping, and I had some sprinkler water stains on the driveway. You know, all those violations were addressed. I don't think they were part of this hearing. But
Well, I mean, those are violations in a legal structure. It's like nothing really been resolved. It's like
right, as far as that goes.
I have a
hasn't
question.
been
I mean,
resolved.
if that was a conversion of a utility structure into a livable space, there was where the permits pulled for electrical, for plumbing, for
right.
I mean,
Right.
all that still has to be complied with.
Right. I was under the impression that already was done, but apparently it hasn't been done. So I'm going to have to get after the fact permits.
So the minor repairs might be completed, but you still have the process of getting
The big issue is still
the big
there.
issue
Yeah.
is getting all the permits pulled.
Right.
Okay.
is this property zoned for multifamily?
No.
So basically, you're gonna have to rezone it. You're not gonna get rezoning on that, man. I don't think correct me if I'm wrong.
He has to go in front of the Board of Adjusters and make a case.
I don't think you're gonna win that case, my man.
Well, I was told that I could get approval as a granny flat, so I wouldn't be able to rent it out, but I'd at least be able to leave the structure as it is, rather than tear it all down.
I'm sorry, quick question. Isn't it unsafe? How would rezoning it make it safe?
Well, I'm not sure why.
But it's unsafe right now because it was illegally converted without permits.
Yeah, when there's no inspections, it's going to be deemed unsafe.
Once he gets all the permits complied with, it might.
First, he would need to go in front of the board for variance. It's sitting in the setback. Then he would need to, if approved, he would need to then apply for permits to bring it up to code.
Right.
And thereafter, it can be, if it can be used as a granny flat, it can only be used by a family member of the owner. I don't believe it can be rented. That's something that has to be taken up on the civil level.
One other question. Besides all the other permits required, was the original structure, when it was first built as a utility shed, was that built with a permit?
Yes.
That was?
Yes.
Okay, there's a record of that in the building department?
Yes.
Okay.
Yeah, since this happened, I actually went down and looked up all the records to see what was permitted and what wasn't. And much to my surprise, there were issues that weren't permitted.
So what was your recommendation?
We recommend to give the owner 154 days to bring it in compliance so they can go to the variance process. Thereafter, a fine of $50 a day if not complied.
Can I get a motion? I just want to make sure that there's no tenant living there.
No, it's empty now.
Yeah, it's empty. That's my
That's why
my only concern.
It took me over 2 months to get him out, but it's empty now.
Yeah.
I'm just very skeptical that you're going to be able to get approval for a second living unit, man. And if you do, it's going to be easy $50,000-$60,000. Are you prepared to sink that kind of money into it?
Well, I'm going to see how it goes with the.
I'm just letting you know. I mean, you're bringing it up to 2025 code. You're bringing up utility. You're bringing up a utility structure to 2025 livable building code. That's not going to be cheap, man. That's what I'm.
Those are power lines right behind it also.
And that's what I'm saying. I
Yeah.
think at the end of the day, you're wasting 180 days, and all roads lead back to demolishing, reconverting it back to its original.
If that's the case, then I'll have to demolish it, but I'm going to try to keep it the way it is first.
Okay.
Yeah.
Then go ahead.
Yeah, I have no problem. Yeah, as long as there's no tenant there, I don't have a problem.
No, it is empty now.
Yeah. I move that we fine for the city and the violation exists as alleged, and that we order the property owners to come into compliance by January 27th, 2026, or a fine of $50 per day, or a fine of $100 per day per violation will be imposed and recorded.
I'll second that.
Sorry.
Ed Murphy.
I'm sorry, January 27th?
Yeah, January 27th, 2026. So basically, you would come back here, you would have another hearing, you would tell us where you are in the process, unless you're able to solve the issue before then, but you have to stay in communication with your inspector, and then we decide from there whether to extend or send it to a Massey where you would start to accrue fines.
Okay, thank you.
Thank you.
Anything else?
Motion's on the table.
Did you second it?
Yes, I did.
All right.
All those in favor say aye.
Aye.
Any opposed?
Okay.
Thank you.
Our next case is on page 9. Senior Inspector Jorge Martinez, property address 301 Southwest 2nd Street. Owner 1129 Van Brunt LLC, 129 Van Brunt GP LLC, and all others. Case number BE 231-00214. Notice posted at the property on 8/4/2025. Posted at 1 East Road Boulevard on 8/12/25. This case was first heard on 9/24/24 to comply by 3/25/25. One section at $50 per day, order recorded, not complied. The city is requesting to impose fines of $1,700, which continues to accrue. There's one extension noted.
Sorry, is the address 301?
Yes.
Okay. Inspector Martinez updating case on behalf of the city. Case number and address as read. The city at this moment is requesting for a 79-day extension. I'm going to let the respondent speak.
Good morning. My name is Kevin Berman on behalf of the ownership of the property. I believe the 79 days, does that cover through October, the week of October 6th?
Yes.
So we're working with the historic board on this. The tenant is actually, which, by the way, if you want to reference that it's under 307 Southwest 2nd, which was part of the confusion in the past. So the tenant is dealing with the historic board, should have it rectified by October 6th meeting, and we would be just asking that the fines would be waived or not levied on the property until that is determined with the.
Not at this moment.
Not at this moment.
Correct.
So there's no fines at this moment.
No, the fines are accruing until today. From today on, we're gonna stop the fines.
So they're starting.
They already started.
They already started.
Today they're gonna stop.
And that's the 1750 number.
Yes. And when you comply, we're gonna address the fines.
Okay, and then the 1750 at that point, you're saying would be considered for waiving if
I cannot waive the fines. The board can waive the fines.
But,
Is this a residential property or commercial property?
It's commercial.
Chemistry?
It's chemistry, yes.
Gotcha.
It's the ongoing. We've been here before you in this matter.
When did I thought we had given an extension.
I had thought that as well, except
is this
there was-
accurate?
Well, there was a mix-up with the addresses.
Oh.
So the address with you is the 301, but the address with historic was the application was put under 307, which is the whole property, 301 to 307.
There's one extension, right?
Can the city chime in? Because I thought we had done extensions on this one.
Yeah.
No, last time we
multiple.
sent it to a Massey.
Yeah, well, correct. This is correct. This first originated back in September of 2024, right? So what's this? We're coming up on a 1-year anniversary. Why is it a fence? This seems kind of.
Well, because it's a historical, so it takes time, and they have to get approved first.
Well, I used to be on the Historic Preservation Board, and it doesn't take a year. So I mean,
Correct. It doesn't take a year.
Were does it respond to Dragon Butt at any time, or is it just City Hall taking its sweet time?
Well, I know they had a meeting with the historical last time, and it was denied. So they put a new date for October.
Why was it denied? Any reason why it was denied?
It wasn't that it was denied. It was, from my understanding, and the tenants are here. They're the ones working to get it rectified. It was. They said come back, change the application, and bring it back with the alteration. And part of the delay has been that they only meet every so often. However, they've been more regular lately, and they will be at the next meeting. The tenant will be at the next meeting with the plans for approval. And they've worked hand in hand. That we've got it down to what would be approved, apparently, is that they want 30% visibility from the street level.
Yeah, I remember the issue being originally that there was that open area, and then you would get there every morning, and there would be homeless people sleeping there.
Correct.
And then so they put up it's like a wood fence with like hedges to like block that area.
The faux hedges on
Faux
top
hedges,
of
yeah.
a 4-foot planter, wood planter, which is what needed to be approved, but it can only be approved if they alter the hedge part, where the faux hedges have to be visible to allow visibility of 30% to the building.
If I recall, the only historical part is that one building that used to be the original gas station.
Correct.
Downtown.
Correct.
So that's the only historical part, not the building, just that one little corner.
That is correct. It's just the corner, and it is visible now from the corner, but it's going to be moved so that way it's directly in front of the historical building. Part of the issue was, yes, it was put up to keep the vagrants from using the property. There's besides overhangs, and there's running water and electric, and it became a refuge for everybody. But it's also for them. And for really the city's look at it is that it's provided security at night when they are open for business, that it's crowd control. And I think we brought up one of the meetings in the past, there's even been some shots that were fired and bullets that were lodged inside the planter. So it actually did prevent people from further injury. Yeah.
I move for a 154-day extension.
When is the next HPB board meeting?
October.
The
think it's October
HPB
6th.
meets every month, so I'm not really sure
It's
what.
October, it's the week of
They meet every
October
month.
6th.
You want to wait? You want to just do 79 days so we can get an update? How about that? Okay, so I'll remove that motion. I'll move for a 79-day extension so we can get an
That's
update.
your meeting.
Yeah, our
Right.
meeting's going to be November 13th,
Yeah,
2025.
we'll be
just so
good.
we know what's going on.
Yeah.
And we get your next
Are we
steps.
accruing fines or stopping fines?
I mean, I didn't know fines were accruing. I'm going to move to stop fines and move for a 79-day extensions. But it doesn't look like fines are accruing at the moment. Oh, maybe they are?
It continues to incur.
Oh, it continues to accrue. Yeah, I'm going to move to stop fines and move for a 79-day extension.
Second, Jackie Shaw.
All those in favor say aye.
Aye.
Thank you for your time here.
Thank you.
Sir, what case are you here for?
That's right. Here's
Hello.
Ah.
Did he sign in? Because he's not here.
Yeah.
Okay, well,
Yes.
just to hear it, he can't speak on it.
Oh, okay.
What page is that on?
What is it? Page?
Oh, okay, okay.
6.
2730.
Our next case is on page 6. Property address 2730 Southwest 17th Street. Owner HPA US1 LLC. Case number BE 250300153. Notice posted at the property on 8/5/2025. Notice posted at 1 Eastward Boulevard on 8/12/2025. This case was first heard on 7/22/2025 to comply by 8/26/25. One section at $50 per day. Order recorded, not complied. Board, we do have a respondent here, but he doesn't have the proper power of attorney, so he can't speak on it.
Okay, Preston Mark, Building Inspector for the city, presenting case and address as read. This case is not in compliance, but there are permits in process. The city's will support an extension of 79 days and state of fines.
What do they have done? What can they get this done in 39 days?
Yes. They're in the process of getting permits right now.
What do we have here? We got green lights. Someone else go for it. Yeah. And the backup mic. I'm moved to give the respondents a 28. How much?
79.
79-day extension and continue to stay the fines.
There was a mandatory appearance, so if you'd like to add that again.
Oh, a question. I mean, if it's a mandatory appearance, who showed up here on their behalf?
He's there.
What happened? Are you the owner? What's the deal? So where's the owner at?
The owner is an institution there are state, so
Institution?
they hired a general contractor who filed permits, but there was a revision being passed by the city. And going back to the architect who modified the plans, this is what caused the delay. So they're proactive, they want to conclude this. And they just need
Is he sworn in?
30, 40 days.
he doesn't have the proper paperwork, that's why he's not in.
Well, I mean, we don't have to take his. I just want to know where this owner's at. Oh, yeah. I mean, again, we say mandatory and we give them like a month's notice and it's like, so I mean, just want to know why they're not here.
Or they're going to comply with the next mandatory appearance.
We supply the legal, we supply the legal papers when the contractor files the permits with the city, the permit application.
Could be many.
And we didn't think we would be in this position to exceed the time allotted initially, but there was a revision requested.
All right. Well, anyways,
28
motion on
days?
the table.
What's the motion?
79-day extension, continue to stay the fine, based on the city's
And
recommendation.
mandatory-
Who seconded?
Do you want the mandatory appearance in there too?
Inspector, do you think this will be fully resolved in 79 days?
I can't say that, sir.
I amend my motion to include a mandatory appearance. Hell or high water, your guy needs to be here next month, man, or in 79 days. This is not fully
Or a
resolved.
POA signed, so you can be there.
And just so the board is aware, the city, in all its notices of hearing, sends out as part of that notice specific communication that if you're a representative, you need to bring a power of attorney to the hearing. That applies to code board and to magistrate hearings.
Okay. Yeah, I'll second that. 79-day extension, mandatory appearance, and what was it? Stay the fines.
Stay the fines, yeah.
But I don't think there are any fines accruing, but if there are, yeah. So I second that.
All those in favor say aye.
Aye.
Any opposed? It passes.
Thank you.
At this time, board, the city's requesting a 5-minute recess.
Take a break. Is it lunch?
Board hearing, recalling case on page 6, 2855 West Commercial Boulevard, case number BE 25040071.
Good morning. So, Mr. Chair, for the record, Rhonda Montoya Hassan with the City Attorney's Office, conferring with counsel. Counsel has conferred with her client. They do not wish to waive their Massey, waive the notice provisions, so we will be coming back for a future Massey hearing. And then counsel also indicated that she would like to argue the motion that was just shared with you on the recess, which is the motion for extension of compliance deadline, reduction, well, aren't really, reduction of per diem fine amount and or reconsideration of order. So that's what we're here to listen to today. And we will reschedule for the fine imposition on another date pursuant to Florida statutes and the city code. You're going to be hearing argument from the property owner's counsel about an extension of time.
Isn't this the same motion we had last time when they were in trial that couldn't be argued because he was in trial?
Yes.
So how is it possible that it's being argued now?
We are requesting a retroactive extension of the compliance deadline in this case. This motion was filed with the city in advance of the last hearing. We intended to be here for that hearing. Unfortunately, there was a conflict, but we would like to make the argument to the board for why an extension of the original compliance deadline should be considered today, in addition to a reassessment of the per diem fine amount based on Chapter 162 in the city's code.
I was in agreement before when he couldn't get here because he was in trial. Where is he today? Whoever the counsel was where we granted the extension because he was in trial?
It is both myself and another attorney, yes.
Okay, I understand.
So what prevented you from arguing this last month? Did you need him to hold your hand?
We were both leading this case, and unfortunately, we were both in trial during the period that the last hearing was set.
So who was here last month?
There was another attorney from our office.
Oh, I'm sorry. I got you confused with the last girl there.
That's okay. No
My
problem.
apologies. So,
No problem.
You can prove that you were actually in fact in court, correct?
Absolutely. Absolutely.
Yes,
we did send
they
a
provided
motion.
that information to the city.
We attached the trial order to the motion for the last hearing. If I may, I would like to make argument on this motion for the board's consideration. As I mentioned earlier, understandably, the city took the position at the first hearing, the board took the position at the first hearing that some media coverage warranted a higher fine amount in this circumstance, in addition to a very, very short compliance deadline. The city's recommendation was 58 days. The board came down with a 15-day compliance deadline. At that time, the work that was understood to be needed to be performed was substantive. It was structural work that the city believed was going to be required to cure this violation. In retrospect, now having attended the inspection, it is clear that what happened is, unfortunately, the news took hold of this case. There was substantial media coverage. There was a lot that was said. There was a lot that was reported about evictions and things of that nature, things that did not occur. And the actual work that was done was very, very minor. They removed sheetrock that covered existing infrastructure, existing kitchenettes. That was the extent of the work. There was some additional things that needed to be done in order to attach those kitchenettes to the existing plumbing and electrical infrastructure, but you're talking about work in 12 units total. 15 days was, in our opinion, unreasonable in this circumstance, and the board is required to give a respondent a reasonable amount of time to comply with the violation. We have worked diligently to address this. Again, we attended an inspection. We did our best to figure out exactly what needed to be done. The property owner understood that because the work was minor, it shouldn't have been required that a structural permit was pulled. We discussed this with the city. We did everything we could to make it clear that nothing substantial had been done at this property. And ultimately, we did pull those permits and we did come into compliance. In addition to that fact, what was conveyed to the property owner originally as what was required to come into compliance was different than what was actually required. And we really only came to know what was required at the inspection that we attended. So we would request, with respect to the compliance deadline, which I note again was 15 days from the first hearing, that the board reconsider the date, the time that was given for compliance in this situation. We made every effort to figure out what was required to come into compliance with this code violation.
So I have a few questions I could start. I'm sure Don wants to jump into, but when the inspector first came, one of the issues you're saying is you weren't able to figure out what you were supposed to do at the time. But when the inspector first came to us and we had this hearing and nobody showed up, the inspector told us that he had issues meeting with people, that he wasn't allowed entry to anything, and obviously there was the news coverage about using these building, I guess, fixing these things as pretext for evictions, and that was one of our issues, obviously. But one main thing that I'm pointing out, like your argument that that you weren't able to figure out what was going on, but the inspector was the one who said he couldn't actually get into the property to find out what the issues were. So, do you have any response to that?
I won't speak for the inspector. I can tell you what I know. My client was in attendance at the first hearing. He did not have a valid power of attorney, so he couldn't speak. He had every intention of conveying to the board exactly what I have just conveyed. I also understand that the inspector, who has been wonderful to work with throughout this process, I believe it was a misunderstanding as to the scope of work that was required. There were photos. It's not like he didn't see what was inside. That evidence was presented to you. The big issue that I saw when I first got involved in this case was the addition of these AC splits that was specifically listed in the violation in addition to these structural issues. I know there was a photo of a door or something like that. That was the extent of the evidence that was put on at that first hearing. When we really got under the hood and determined what was happening, and I believe, and if I'm wrong, Inspector Jabia, please feel free to correct me, but I believe that Mr. Jabia did inspect the units at issue, the 12 units. So it's not as though he did not have access to them at all. We just weren't sure what exactly the corrective measures looked like because our understanding of the scope of work that had been performed was so different from what had been laid out at the first hearing.
So, Mr. Chair, if I could just respond to some of the allegations, and counsel hasn't raised a lot of, in her oral argument, a lot of the issues that are in the written motion. I would certainly take issue, and obviously the board is going to have a better understanding of why it imposed the high fine. I would suggest, though, to the board that the media coverage was not the reason for the higher fine in and of itself. And as board member mentioned, I think part of the issue was the lack of responsiveness. Council is correct that once the process started once we were all able to meet out at the property. I myself attended, both council attended. It took a lot to get to the finish line, in my opinion, based upon my experience of almost 30 years in doing building code enforcement. The contractor, the general contractor, very nice man, very confused. He should know what work was done, and he should have been able to quickly resolve that, again, in my opinion, with the inspector. It took a large group of us to get together, a lot of back and forth, a ridiculous amount of emails, again, in my opinion, for what needed to happen. Then there was emails over and over and over about voiding certain permits. That took the longest time. The contractor didn't have insurance. He didn't have workers' comp in place. Again, these things happen, but it's, and again, no fault of council, or maybe necessarily the property owner, but it just seemed that the general contractor wasn't able to expeditiously resolve these issues that really could have been resolved in short order. Obviously, I'm going to rely on the inspector. I do believe, as you mentioned, that he said that he did not get a lot of cooperation. I do take issue with a lot of the statements that are in this motion, but again, council hasn't necessarily raised them, so I'll just, I guess, leave it at that to not belabor all of the points in here. I think under the circumstances, when you go back, you're kind of talking on both sides, right? You're saying, well, the property owner is saying, well, we thought it was going to take a lot to comply the violation. Really, the general contractor should have known that. The general contractor should have been able to produce and understand what had been previously permitted, what had not been, what work he had actually performed. This is the contractor that performed this work. That should have been resolvable in a quick and timely fashion, particularly when it was, at the end of the day, just voiding some permits and getting some MEP permits. It should not have been that complicated. It was able to get to a successful resolution because of the continued emails from council. Again, in my experience, fairly atypical. A general contractor should know. And I told him as such when we were at the meeting, that his assistant seemed to know more what was going on than him, which was a little troubling to me. And this is not, again, this is of record because I said it in the meeting. So the city would disagree that it was not, that it was a reason, and state that it was a reasonable time under the circumstances to comply. And again, it took far more time than even the board gave for a relatively simple matter.
If I may briefly respond, what happened here is, I understand that there were some issues with the contractor, but to penalize the property owner for what were really, at the end of the day, administrative, and not to mitigate how important they are, but administrative paperwork issues such as insurance and workers' comp, which is ultimately what really prevented the property owner from coming into compliance at the end of it. Once we determined that the only two permits that were required were for plumbing and electrical, to penalize them in the manner which the original order does, when the property owner was working to come into compliance, we were emailing the city, we were making diligent efforts routinely, daily, to try and figure out what we could do to push this thing forward. It feels very prejudicial in this case. And again, what we're talking about here, it's not as though the property owner did nothing. Even if there was confusion on the part of the contractor, we were still making efforts to bring this property into compliance. The contractor was still at the permitting counter every other day. We were constantly working toward bringing this into compliance with the order.
My issue still is with the first, not hearing. You guys, this is fine. My issue is still with not the first hearing, but the first inspection, like what actually occurred there. And then there was no one present at the first hearing to make these arguments, which is why we, I guess, threw the book at this.
I think that if we didn't impose this $1,000 a day fine, you'd be up here right now asking for us for a 89-day continuance, 60-day continuance. You would be nowhere near resolving the situation. I honestly think that you have a fly-by-night contractor. I believe you came here with fly-by-night engineering. So if we didn't put the hammer down, this would still be in non-compliance, and you'd be begging us for more time, more time, more time.
Respectfully, and I mean that, respectfully, at the first hearing, the understanding was that over 120 units were going to have to be renovated. And that compliance deadline was given under that understanding. Ultimately, it turned out that the scope of work was much less than we understood, than the board understood at that time. But that was after that first order had been entered. I understand that there are a lot of circumstances here that the board is considering. I understand that there is a question as to why no one was at the first hearing. We were not retained at that point. More than that, as I noted, our client representative was in attendance at that hearing. He did not have a valid power of attorney. He is not an attorney. He didn't know that that was a requirement.
Your client wasn't even thinking about lawyers, because again here, we didn't need lawyers until the situation got real. Then when $1,000 a day fine, we're going to lawyer up now. Again here, you guys never took this serious whatsoever.
I would
And
respectfully.
again, just for the record, the client did know that a power of attorney was provided. As I stated earlier in another hearing, what is mailed out to all property owners along with the notice of hearing is that if there's going to be a representative coming to speak, that they need a proper power of attorney to be brought to the hearing. So that was in fact mailed to the property owner, again, before council got involved. So the property owner would have had notice that if someone other than an individual in that corporation was going to appear, they needed a power of attorney.
If I may, I would also respectfully disagree with that characterization. The reason, and everyone has a right to counsel if they choose to retain them, but the reason why an attorney was not present at that first hearing was because the property owner did not believe that the scope of work was exorbitant, and it ultimately turned into something much different at that hearing, which we then tried to remedy. So it was not that the property owner undervalued the violation. It's not as if they ignored the code or the requirements thereof. They simply understood or believed that the work that they were doing was very nominal and not substantive in the manner that the board ultimately determined that it was.
I'm not sure how that justifies not doing the power of attorney and speaking regardless of the work, the scope of the work from the client at the first meeting. I'm not sure what you're saying there.
In terms of the power of attorney, I cannot speak for why a power of attorney was not filled out, but I do know that when a form is sent to a property owner and they're not an attorney or they're not well versed, this property owner has no other violations prior to this. There's an existing business tax receipt violation now, but it's not like they have an experience with code enforcement, with working with the city on these issues. This business has been in existence for some time. So it is a new process, and the client representative just wasn't aware of that requirement.
One thing I'm looking at is just like being a general contractor. I don't like when people just dump everything into the bad contractor pile. That anybody who hires someone, you have a responsibility to keep an eye and watch it. You're not a homeowner hiring a kid to cut your grass. You're hiring someone to go into your multi-million-dollar facility to do renovations. You should have a checklist, a schedule, or something to monitor. For him not monitoring what was going on, then shame on him. You know?
I understand. Again, what we're talking about here is a 15-day compliance window from the period of the first hearing. I understand all of the issues that the board is taking with the way that the contractor went about the issue, the potential issues that arose throughout the process. But at the end of the day, the compliance deadline that was given was 15 days, which the board itself acknowledged was an impossible compliance deadline to meet. We are requesting, based on the multitude of circumstances here and what ultimately transpired, that the compliance deadline is extended and retroactively, and that they are given a reasonable time to comply that is not 15 days in this case.
I think she just said that 15 days was doable, and it was only your clients and the contractor's own actions and inability to get it done. Didn't you say that it was doable?
I did, I did, because again, the general contractor knew the work that he performed without permits. Whether the client did or not, as the other board member said, the owner has a responsibility, any property owner has a responsibility to supervise and understand what work is being performed on his, her, or its property. To void a permit should literally take a day. To get a mechanical and a plumbing permit, these are simple permits. And again, the delay of having to have a meeting on site and then, having a discussion and then the contractor not having the proper insurance in place obviously also begs the question, were they doing the unpermitted work at the time without even any insurance in place? All of that takes us, down to where it now is in compliance days late. But those three things, if the contractor had gone directly and worked with the inspector or just gone to the permit counter, and you've got a board member, the general contractor should know how to obtain those and get the case resolved in very short order. And 15 days, if they had jumped on it, putting aside the fact that they started work without permit to begin with, could have been accomplished.
Okay. If I may respond, the contractor immediately following the first hearing submitted a structural permit. That was what was understood. It is not, the contractor did not believe that it should have been required based on the work that was done, but based on what was being conveyed to the contractor by the city, a structural permit was pulled, and it was pulled very quickly. Ultimately, that did not end up being required, but it's not as if nothing was done in the period between the inspection that we all attended and the first hearing. That inspection clarified that that structural permit was never required and that it was a much more narrow scope of work than had been understood. So it is not as if nothing was going on between that initial period. We were doing our best to work within the framework that had been given to us by the city and based on the order of the board, which again was very different than ultimately what was required to come into compliance with the violation.
Who dictated the scope of work to be done? It wasn't a general contractor. Somebody told the general contractor what they needed to do, what work they did. Was there an architect involved, or the owner just said, I want you to do A, B, C, and D?
It was the owner. The owner conveyed to the general contractor what was to be done.
And the general contractor never said, wait, this is more extensive than we talked about, we might need a permit?
It was not believed that the work was extensive. When I discuss what actually was done, it is literally the removal of existing drywall. The drywall was taken out and placed on the wall to the left of the kitchenette structures. That's it. And the kitchenette structures, the stuff that was behind the drywall, has been there since this building was constructed. So when Mr. Ford and Mr. Pasquarillo from the building department came out and they saw what had been done, it was agreed that the work did not really require a structural permit because the structure itself had not been impacted. It was just the removal of that drywall. And then it was a matter of determining whether or not an electrical permit was required and a plumbing permit was required for the reconnection of the infrastructure within those pre-existing units.
Again, that would not have affected the first hearing. That was after our first hearing. So I still think that our judgment made during that first hearing would not have been based on those facts. That's my issue that I'm running into, because that would not have been presented until the next hearing, where no one also kind of showed up. They didn't really. You didn't really show up, but we would have. I don't know. It wouldn't have changed our judgment on that first hearing. That's my only issue I'm running into.
So at this point, Mr. Chair, the issue, I guess, before the board would be whether or not there is a desire to accept a motion for extension, a retroactive motion for extension of time, and if so, for how long? And if there isn't, then I guess the board should decide that as well.
What was the original inspector's recommendation?
Your original recommendation, Andrew, when we had our first hearing.
It was 58 days.
I got a question for council. Let's just say we were to retroact. I got a question for council. If we were to go back and retroactively give you time to comply, would you, if we make a deal like that, would you take the deal today, no questions asked? Meaning, if we throw you some mercy today, you're not going to come back. If we give you some relief today, I want that to be the final thing. No more coming back and saying we want more, we want more, we want more. So let's just say we were to give you a full 30 days to comply. So I'm giving you $15,000 or was it 14,000 more? If we were to give you that off the 70 grand, would you take it and go?
We would not waive our right to a Massey hearing on the fine mitigation in this case.
Okay, so you want us to give you, you're going to chip away now and then chip away a month from now.
Respectfully, that is their right under Chapter 162.
Try to negotiate here.
I understand.
I mean,
That is, this is a unique case. I think that the board agrees that the hammer was metaphorically dropped on this client, this property owner. We're just trying to figure out how to move forward in light of what transpired, and ultimately the permits that were required to be pulled were for very minor work. The 15 days is unreasonable in the circumstance. We are requesting, based on the totality of circumstances here, that the board reconsider the compliance deadline that was originally granted to this property owner.
The motion, the entire motion, you said during her oral argument, or what she's standing there saying now, that she didn't address all the question, everything that was in the motion. I don't have a copy of the motion in front of me. And you said that you had issues with some of the things that were in the motion. I'm a little worried that if the motion is part of the record and we're not addressing it, could that be a problem down the road?
So, potentially, I can go through it, or we can even take a recess if the board wants, so everyone can read it. It's like I said, part of it was the issue that the city or the board made the finding because of the media presence. It says that Mr. Leonor remained present and engaged with the city code inspector throughout the hearing, even though he was not permitted to speak. That is not correct. He left after he was told that this was heard as a no-show case. There was no one in the room at the time. The motion says that Mr. Leonor was advised by Inspector Gebbia that his presence was unnecessary and that he should leave, especially in light of the intense media attention the case had garnered. Inspector Gebbia never told the gentleman to leave. We would never tell anyone to leave. We regularly have folks here that don't have, whether a code board or magistrate, that don't have power of attorney, that are obviously welcome to sit and listen to the disposition of their case. So, and certainly you could hear from Inspector Gebbia directly, but he did not advise Mr. Leonor to leave, and he definitely did not advise him to leave in light of the, quote, intense media attention the case had garnered. So we would take issue with that. The following paragraph says, in reliance upon this representation and in good faith, Mr. Leonor exited the hearing. So we would take issue with reliance because that advice was never given to the property owner representative. The motion says it became clear that Vice Chair harbored a strong personal bias against respondent on account of the recent media coverage surrounding the alleged violation. I would certainly take issue with that. There's an allegation in paragraph 17. Ms. Hassan further suggested the imposition of a more severe daily fine based upon a recent amendment of the city code. I would take issue with that. I did not suggest the imposition of a more severe daily fine. I said that that was available to the board. I typically don't. Sometimes I do, but typically do not suggest an amount of a daily fine. Let's see. I would take issue with the characterization in paragraph 21, which says, although visibly hesitant, the board ultimately imposed what it understood to be the harshest penalty available under the law. Again, I would take issue with that characterization. Those are the factual allegations that I would take issue with. And then again, the issues that council has already raised, we take issue with regard to the reasonableness of the 15 days.
We have also argued in the motion that a reduction of the per diem fine assessment is warranted in this case based on the statutory criteria and the criteria in the code. I am happy to make that argument, and I would like to, but I was intending to make that after the compliance deadline issue was addressed by the board. Additionally, I am more than happy to have Mr. Leonore, who is here, speak today about why he did not speak at that first hearing if the board would like to hear from a witness. It is up to the board. We believe, based on the circumstances and what transpired, we stand by the representations made in the motion. I think the board did understand that this was the maximum fine assessment from a resolution that had been passed 5 days prior to the first hearing. And I also believe that the board understood that 15 days, because it was stated on the record during that hearing, was a near impossible deadline to meet. So for those reasons, and again, I'm happy to put Mr. Leonore on it if the board would like to hear from him. But for those reasons, we do request an extension of the compliance deadline, and further, to the extent that the board is willing to hear it, a reduction of the per diem fine assessment based on the strict statutory criteria in Chapter 162 and in Section 1112 of the city's own code.
Question for you. What's your definition of extension? Extension. You're asking extension. You're asking for more time. So throw a number out.
Sure. We would request that the original compliance deadline that was offered by the inspector in this case, which was 56 days, run from the date of the inspection that we attended, where it became clear that the permits that were required were for exclusively an electrical and plumbing permit.
The city would oppose that, of course.
Of course. Two things. Number one, I'd like to note all the media presence in the room tonight. Glad to see all the reporters here today. Same thing last month as well. This place was chock full of reporters last month. There was one reporter at the first meeting, and nobody knew why he was here until the case was read. I'd be willing to, just floating out to the board, we could talk about this here, I'd be willing to retroactively give you 15 extra days. So that would make it a full 30 days to comply. Not from the day of your inspections, but from the original hearing. So basically, we're giving them a break of $15,000 in the fine, basically. So I'm giving you 30 days. I mean, 58 days it's, I'm sorry, just not reasonable. But again, just to show we're not, as crazy as you think we are, I'll give you an extra 15 days.
I had one other question. What was the date of that inspection that everyone met? I couldn't find it. I was just trying to find it in here.
If I may, I'm going to have to go through my calendar. I tried to look before I came up again, but I was not successful in locating it. I can look through my calendar very briefly if the board would like to know exactly what that would look like, if you give me a brief 5 minutes to check.
Go for it.
Thank you so much.
Thank you so much.
I want to say it was July, but we'll look. Yes.
Again, the inspection would have been at their convenience. That's the whole thing. It's like, we'll get around to it.
No recess. It was Monday, July 14th. The inspection was Monday, July 14th
When was that originally requested?
at 2 p.m.
When was that originally requested? I mean, I'm sure you're not going to do next day inspections or next day meetings, so.
Let me look.
If you don't mind looking up. I think it's irrelevant at this point. I mean, you took over a month to get an inspection scheduled. I think that the fine starting at the inspection date is just, it's a non-starter. Let's not waste our time here. Again,
If I may briefly respond, during the initial period, there was multiple resubmissions on the structural permit.
Okay.
They were addressing comments on the structural permit.
Okay.
It was when we became involved, when we looked at the plans for the property and saw that the units, the kitchenettes were pre-existing, that we requested an inspection where everybody was in attendance.
Okay.
But again, there were active efforts being made on the structural permit during the period between the initial hearing and the inspection that occurred.
all right, great. I make a motion to retroactively grant 15 extra days to comply as not requested, but that's what I grant, or that's what I move.
Yeah, I'll second
Wait,
that.
I have a question before we do that. Is there any, we are at 70,000, obviously. You want administrative fees only. What would you settle for? We were at $70,000.
Thank you so much. We are very happy with the city's recommendation in this case of administrative fees. We believe that that is fair in this case where we have diligently worked to address the violation. I also believe that that recommendation does take into account the circumstances. If the board is inclined to grant a reduction to administrative costs, that is not something that we would fight with.
And so, Mr. Chair, just so everyone's aware, I found an email dated July 7th from council that's present, that states our legal assistant will be in touch shortly with a few proposed dates and times for later this week or early next week. So on Monday, 7/7 is when we started discussing the times. Then they proposed some times later that day, and on the 8th, the following day, we scheduled the inspection for the 14th of July, all in July.
Is that normal for you to attend inspections such as these?
No, it's not normal. I mean, I have over the years, but no, it's not typical, certainly.
So we gave them certain allowances that we don't usually do.
Well, council I know was going to attend, so, obviously I wanted to attend if their council was attending, and vice versa.
I don't think we can go any further. You're saying 0? If you're staying on 0, administrative fees only, there's nothing else we can do. We are not, I don't think, we are not willing to be administrative fees only. Is that correct?
Well, that's not, that's certainly the board's decision. And again, that's for the next hearing because council, which is their right, the property owner has not waived their notice for a Massey. So it will have to come back to deal with the imposition of either fines and administrative costs or just administrative costs. That will have to be at a subsequent hearing.
Right now, we are just requesting a retroactive extension of the compliance deadline, and if the board would be willing to hear it, a reduction of the per diem fine assessment of $1,000 based on the statutory criteria.
Oh, we have a motion on the table. Has it been seconded?
Yeah, I seconded the motion.
Hold on, Madam Chairperson. Madam Clerk, call the roll, please. Yay.
Aye.
Aye.
The motion was to add, to retroactively grant an extension for 15 days. So then you would have to adjust the fines accordingly to account for the fact that the property owner was allowed 30 days to come into compliance, and then we'll have to come back for a Massey hearing at a later date.
If I may make argument on the per diem fine assessment, that is the second component of the motion that was served in this case.
We just gave you $15,000 off. I think you should play it cool and come back next month. Unless you want to negotiate a settlement out today. As I said, walk out the door, with the done deal. I think you're biting off more than you can chew, and that might work against your favor. We just gave you $15,000 off.
I understand, but legally there are criteria that must be considered in the assessment of a per diem fine.
Rock and roll.
If the board does not wish to grant the motion, that is certainly within the board's discretion, but I would like to make the argument so that it is on the record. In this case, the per diem fine assessment was $1,000. It was the maximum fine amount that is allowed under any circumstance. Under Chapter 162 of the Florida statutes and under Section 1112 of the city's code, when assessing a per diem fine, there are three factors that can be considered. It is the gravity of the violation, the other violations that the property owner may have on their properties, and the efforts that they made to bring the property into compliance. Based on the record that was created at the first hearing, it does not appear that those factors were weighed. This is a property owner with no other existing. There is, as I noted, there is one companion case. It is a business tax receipt violation that we are working on resolving with the city, but there are no other code enforcement violations on this property. The property owner does not have a record of ignoring the code or not complying with it. In addition, there were efforts that were made by the property owner to come into compliance, and above all else, there is no threat to public health, life, or safety. These units were vacant. There was no one living in them. It's not as if the unpermitted work was being, no one was exposed to it. The units remained vacant throughout the entire duration of the case, and they're still vacant today while we try to make efforts to do the work, the remedial work as is required. No one will live in them until we receive the go-ahead from the city. Based on the record from the first hearing, I understand that Ms. Hassan and the board, I understand that there is a dispute as to whether or not the media presence or the media coverage influenced the outcome of that hearing, but it was stated that the reason the fine was being assessed was because the board wanted to penalize the property owner for evicting people and have them experience the same thing that the people who had been allegedly evicted experienced. That is not an appropriate consideration for a fine assessment of this nature. And more than that, the resolution that was passed that allowed the $1,000 increase, the notice of violation stated that the maximum fine that could be imposed in this case was $500. The fine that was ultimately imposed was $1,000. There is a right to due process. You do have a right to have notice of the maximum amount of fines that could be imposed. There is case law that says that when you retroactively apply something and it's a substantive law, there's a presumption against retroactive application. In this case, I would argue that because the notice of violation contained a maximum amount of $500, because that resolution was only passed 5 days before the hearing, and because the property owner had no notice that there was a maximum of $1,000 a day that could ultimately be imposed in this case, that the fine imposition was violative of due process principles. So we would request, based on the city's code, Chapter 162, and due process principles, that the fine amount, the per diem fine assessment, is reduced.
What's your definition of reduced?
That is within the discretion of the board based on the
What's your
circumstances.
definition? Okay.
So what I do want to say on record is I think you've done a fantastic job. I do want to say, though, that it sounds like you're asking for a cake and eat it too kind of a situation, which I think you would do to zealously defend your client. However, I think what my client is saying, and we're not discussing the media, right? That is not a part of the consideration, even if it may have been said, we're focusing on the merits, right? And so right now, I think the biggest issue for some of the board members that I've been speaking with is that if the violation occurred on May 25th, and based on what the city is saying, their first communication for efforts to move forward and try to get this resolved as seriously as you say happens to be July 7th. That's quite a bit of time for such a large property to outwardly say we're ready to begin truly trying to figure out what's going on here. So I think that would be the criteria that is being most heavily considered here today, not media, not punishment or punitive measures or anything else like that. It's more about the time that it has taken to get a true resolution going to get this resolved. And so as far as notice goes, you, as their hired counsel, and any other representative understands that you would advise your client what the maximum fine is. And so the board has the discretion to implement that. So I don't think this is a case of lack of notice, not if 3 different times you've had someone appear. Maybe it was the second time that happened, the second appearance that happened. But as you said, the statute allows it. So I don't believe it's a lack of notice in that respect, because it's always the potential to be the highest amount, right? It's always that. And so I think those are the issues at hand. And you do have the due process right to come back and further basically negotiate this down. So I don't think you're at a disadvantage or in any situation where you are paralyzed and unable to, without notice, advocate additional reductions on behalf of your client. So that's their position on why they've proposed the additional 15 days to get you to 30. And so again, most of this is based on what looks like, based on dates, an effort to seriously resolve it. I haven't counted this, but this is feeling like, we're almost at a month and change, or more than that. Between May 30th, 6 weeks-ish before it looks like some true progress was made or wanting to be made. So that's the position. Okay.
I understand. Thank you for clarifying, counsel.
And obviously this was an ALF.
Yes.
So there's a concern with there being elderly people and how this is being handled and the quickness or the promptness that it was being resolved. So that is kind of subsumed in the 6 week-ish response time.
Understood. Based on that representation, and I understand, thank you again, the initial fine was still imposed based on the first hearing that occurred, where the issues that you are discussing right now are not in play as of yet.
I understand. So that was a public safety issue. This is an ALF with elderly people. There was a concern that their safety was in jeopardy. So that is honestly what that was about. So this isn't a punishment thing. This is an ALF, elderly people, public safety concern. They had legitimate concerns. So they're standing by that.
If I may briefly respond, these units were vacant. The work that was done did not impact the remainder. They were vacant at the time that the work was done. They had not, I believe that the people in those units had vacated long before the first hearing occurred, from what I understand.
That's what the board understood. I was here that day. So that was a part of the conversation.
I understand, and we weren't here. I understand that there's some confusion about what exactly happened, and that's why I wanted to clarify for the record. I understand that these units were vacant. People were not asked to leave so that the work could be done. There were plans in place to renovate these units. People were given adequate notice of the termination of their leases. They can do that. They have a right to do that.
Right. And no one's arguing their right to evict or...
Understood. But in terms of that, when it comes to a public safety issue where the units were vacant and where there was no harm, because there are separate wings in this facility, these wings are completely separate.
So I think that can be argued at the Massey hearing, if I'm being honest, just because I've spoken to them, they're settled. So if you want to bring those arguments back for Massey, obviously you have the right to do so.
Sure, understood.
And Mr. Chair, just to clarify for the record, the Florida Statute 162 has always, or for years, allowed a $1,000 daily fine to be imposed based upon the size of the city of Fort Lauderdale. What we found was that our city code did not match that, and while our office believed that we still could impose the $1,000 daily fine, we thought it prudent to have the city code chapter 11 mirror Florida statutes as it does in pretty much every other respect. It wasn't, as council said, a resolution. It was an ordinance with 2 readings, publicly noticed, and it did pass and was made effective before the date of the first hearing. So again, just briefly, because I know we've gone on a bit, it is the city's position that there was absolute due process. The fines could be $1,000 a day. It mirrored Florida statute, which was always at $1,000 a day. And this is just like when you increase parking fees or whatever. If you get that parking fee or get that speeding ticket after the effective date, and you have to live with that. It's not, in this case, it's not in a retroactive application because the ordinance with the 2 public readings was passed and became effective before the initial hearing on this matter.
For the record, just briefly, and I think we've belabored the point. I really appreciate the board's time today and the chair and the attorneys for the city. We are not arguing that the city is not allowed to impose a $1,000 fine generally. We are just arguing that in this case, because the notice of violation contained language that said that the maximum amount that could be imposed was $500, which was the law in effect at the time that the notice of violation was issued, that it would be violative of notice principles and due process to impose a maximum fine that was not adequately noticed by way of the notice of violation in this circumstance. That is our position on that issue.
I'll get a question for council.
Sure.
With the amendment of the compliance date, we're now at $55,000. Correct me if I'm wrong. Just to save ourselves more arguing next month, would your clients take a $50,000 fine? Take it or leave it? Meaning we'll give you 5 more off, and then you go on your merry way.
But again, Mr. Vice Chair, they haven't waived their right.
I know. I'm asking. You always could change your mind. I'm just asking.
I understand. We would still move forward with the
just asking.
I understand. Thank you for the question.
So we'll see you at the Massey hearing.
Okay, sounds good. Thank you all for your time today. I really appreciate it.
Going back to page 1, our new business cases. Senior Inspector Jorge Martinez, property address 888 Intracoastal Drive, 9B. Owner Gregory J. Gessner. Case number BE 25030238. Notice posted at the property on 7/11/25. Posted at 1 Eastboro Boulevard on 8/12/25.
Inspector Martinez, on behalf of the city, presenting case as read. This building has been illegally altered and construction work illegally performed without obtaining the required permits in the following manner, but not limited to new floors and bathroom remodel. The city will request 79 days to comply or a fine of $50 a day thereafter.
And any contact?
Yes. No, they already applied for the permits.
Okay.
Hold on. How much time does the city want to give?
79.
79 days. I move that we fine for the city, and the violation exists as alleged, and we order the property owners to come into compliance by 11/13/25, or a fine in the amount of $50 per day per violation would be opposed and recorded.
I'll second Ed Murphy.
Aye.
At the bottom of page 1, Senior Inspector Jose Saragusti, property address 5100 DuPont Boulevard, 10A, case number BE 24100007. Owner Richard Romanelli. Notice posted at the property on 7/14/25, posted at 1 East Broad Boulevard on 8/12/25.
Inspector Saragusti, on behalf of the city, presenting the case as read. The city is requesting to withdraw this case from this hearing.
Withdrawn. Thank you. Yeah.
Is the wrong folio number of the case?
Yeah.
Yes.
Hole in the wall, that's being dealt with though, right? I mean, that looks pretty like Surfside Junior there, man.
Page 2 at the bottom. Senior Inspector Preston Mark, property address 340 San Marco Drive. 2 at the bottom. Owner MDS Real Estate 341 San Marco Drive LLC. Case number BE 25050087. Notice posted at the property on 7/11/25. Posted at 1 East Broad Boulevard on 8/12/25.
Preston Mark, Building Inspector for the city, presenting case and address as read. This property was cited for violation under Florida Building Code 105.1, work illegally performed without obtaining required permits. This included, this is a new construction, and there are several items for construction that was completed without permits. It includes the installation of a pool, a perimeter CMU wall, and various concealed work that without calling the inspections. The case was opened 5/7/2025. Inspection report mailed 5/8/2025, and code board notice mailed 6/17/2025. Further to a city's review, this project was cited as per above. We issued a stop work order, which currently is in effect. At the time of my visit, there were several workers doing plumbing, framing, installation of windows and doors, etc. The city did request a review of the permits by the chief inspectors for plumbing, mechanical, and also structural. At present, we are still in the process of reviewing permits that are not issued. I was hoping that the respondent would be here to speak, but apparently there's no one here. The city is requesting that the board find the violations exist and grant the property owner 28 days to come in compliance, or a fine of $100 a day thereafter.
I have a question. Can contractors or subcontractors be fined for going into a property that has a stop work order from the city?
Yes.
They can be fined and arrested.
What's the deal
It's a
with this, man? This
misdemeanor.
looks like a nice house. I mean, what's the? I can expect this in like some dump, but a multi-million-dollar house in a $1 million location. Like, what's the story behind this?
This contractor is a repeat violator. He has several projects ongoing in the city that we have cases open on. His name is Mario Monafis, I believe, and we have also had several conversations with him regarding work being done regardless of stop work order. However, there may have been some discussion with the building officials regarding this. If Assistant Building Official Joe Pasquarello is here, if he'd like to chime in on that.
I don't think I was sworn in, Tasha.
Tasha.
She needs to be sworn in.
Are you swearing to affirm to tell the truth at today's proceedings?
Yes, I do.
Thank you.
Yeah, we have responded to this property several times. Every time we, do appear, they claim there's nobody working. So there have been numerous, challenges with this property. So we figured if we could, open up code case, have fines running, and, end up putting a lien on the property that could, get their attention. Eventually, at the end, he's going to have to submit, all the proper documentation for any missed inspections. We prefer not to go that route, but again, there have been many challenges with this property. We've even went to the property with the police department, at which point they as well could not find any evidence that they were working. So it seems like, they kind of slip and slide when we're not around, kind of thing.
I would suggest to the board, if I could, and for the record, Ronald Montoya Hassan, based upon the past experience of this contractor, which I know personally has had a record of like building pools and such without permits, trying to then, as the assistant building official said, afterwards submit documentation because you can't do the inspections, the work's already been concealed, that the board consider imposing either a $500 or $1,000 a day fine in this circumstance.
I got a question. I mean, if this guy is such a scumbag, why does the building department allow him to operate in Fort Lauderdale?
Yeah, I mean, unfortunately, licensing is out of our control. That would have to be a complaint, filed with DBPR. In this particular case, he's an owner-developer, so he'd be able to pull the permit as an owner regardless. I believe he happens to be both.
Hold on, so he owns the property as well?
I'm sorry?
Mario owns the property as well?
I believe so.
Oh, wow. Okay.
It's quite a bit of work done without inspections.
Yes, sir.
I move that we fine for the city. Violation exists as alleged. What's the time frame again? 28 days. We order the property owners to come in compliance by September 23rd, 2025, or a fine in the amount of $1,000 a day per violation would be imposed and recorded.
I'll second that. Ed Murphy.
Can we have a mandatory attendance?
Oh yeah, plus mandatory attendance.
I'll second that.
Yeah, he was second.
All those in favor say aye.
Aye.
Any opposed?
Okay.
Thank
Moving
you.
on to page 3, Inspector Andrew Gebbia, property address 1432 Southwest 26th Ave, case number BE 25040072, owner Juan C. Jimenez, Isabel Molin. Notice posted at the property on 7/15/25, posted at 1 East Borough Boulevard on 8/12/25.
Andrew Gebbia, building inspector for the city, presenting case and address as read. This property was cited for violation under FBC 2023-105.1. Work illegally performed without obtaining the required permits in the following manner, but not limited to: rear structure, white PVC fence, and an enclosed carport. This case was opened on 4/8/2025. The inspection report was mailed on 4/29/25. And the code board hearing was scheduled on 6/17/2025. I haven't had any correspondence with the owner of this property, with an exception for about 5 minutes before this hearing started today. So, researching this property, I found online we have reason to believe that there has been work done to this residence without permits. The white PVC fence installed across the front of the property, and the north side of the property has no permit. There is a carport conversion to livable space, also done without a permit. There are 2 structures, containers, sheds in the rear of the property that are unpermitted as well. The city is requesting the Code Enforcement Board to find that the violations exist and to grant this property owner 154 days to come into compliance, or $100 a day thereafter.
Go for it, Ed. Jackie,
I move that we fine for the city and the violations that exist as alleged, and that we order the property owners to come into compliance by, September 23rd, 2025, or a fine of $50 per day per violation will be imposed and recorded.
I'll second that.
All those in favor say aye.
Aye.
Any opposed?
Property address 1108 Northwest 5th Ave, 1-3, owner 1108 Northwest 5th Ave LLC, case number BE 25040133. Notice posted at the property on 7/10/25, posted at 1 East Broad Boulevard on 8/12/25.
Andrew Gebbia, building inspector for the city, presenting case and address as read. This property was cited for violation under Florida Building Code 2023 111.11. The use and occupancy of this dwelling has been changed from the original permitted occupancy classification of a single family to a multifamily dwelling unit without obtaining the required permits and the certificate of occupancy from the building department. This case was opened on 4/15/2024. The inspection report was mailed on 4/29/2024. The code board hearing was scheduled on 6/17/2025. There are 3 units in this building that are being occupied. This property has a CO stating that is a duplex from 1965. There is a building permit for a wood fence from 2014 stating that is a duplex as well. Excuse me? Oh, no. And our GIS has this property listed as an RD15 single family residence / duplex. There is reason to believe that there is an additional unit added without permit. The city is requesting the Code Enforcement Board to find that the violations exist and to grant the property owner 79 days to come into compliance or $100 a day thereafter.
Is there a particular reason for the 79 instead of 28 to get this guy in here?
Excuse me?
Is there a particular reason for the 79 over just 28 to get him in here? Or have you been in communication with him?
I have been just recently as well. I just spoke to to the property management company yesterday, and he's setting up an inspection with myself next week. There is a disgruntled tenant living in this premises, and I believe the father had a heart attack. The son is mentally disabled, and so on and so forth.
I got a question. How did this get on your radar?
How did this come into my radar?
Was it? You just said a disgruntled tenant. Did they drop the dime on the owner?
More than likely.
So because you said you believe there was a third unit.
I believe there's a third unit.
Did the owner or the manager admit to that?
Yes.
Okay, so there's no belief. It's just
I just say I believe that there is a third unit, but I only have pictures from a third party stating that's a third unit, and I don't have a photo myself of it.
But they're going to grant you access to inspect it out. Okay, fair enough. All right.
All right. I move that we find for the city the violations exist as alleged, and that we order the property owner to come to compliance by November 13th, 2025, or a fine of $100 per day violation would be imposed and recorded.
Alex Schneider will second.
All those in favor say aye.
Aye.
Any opposed?
Hey, can we take like a 5-minute break?
Okay. Our next case is on page 4. Inspector Andrew Gebbia. Property address 2352 Northeast 9th Street 4. Case number BE 2504-0193. Owner, Barbara Skipinski, Maciej Skipinski. Notice posted at the property on 7/15/25. Posted at 1 Eastboro Boulevard on 8/12/25.
Andrew Gebbia, building inspector for the city, presenting case and address as read. This property was cited for violation of the Florida Building Code 2023-105.1. Work illegally performed without obtaining the required permits in the following manner, but not limited to an AC installation changeout. This case was opened on 4/28/2025. The inspection report was mailed on 5/1/2025, and the code board hearing was scheduled on 6/17/2025. I arrived at this property on 4/30/2025. I met the tenant of Unit A4, Eugene Haynes, who was moving out. He was having problems with mold in his unit from the AC inside of his unit. The owner of the unit swapped out the old condenser outside and the handler with new ones. I checked, he had called and complained. I checked records, there was no permit for the mechanical replacement. So she applied for a permit. I have been in contact with the owners of the property. They have a submitted application for AC replacement. MEC-GEN 25050670. The application is currently awaiting client reply. The city is requesting the Code Enforcement Board to find that the violation exists and to grant the property owner 79 days to come into compliance or $100 a day thereafter.
And just confirm you've been in communication with the property owner?
I have,
Yeah, okay,
yes.
perfect. So I move, oh, go ahead.
What's the deal with the exposed plumbing there? This pipe sticking out of the ground. Hold
They
on.
were fixing irrigation.
That's not on your radar, is it?
Yeah, that has nothing to do with my case.
All right, cool.
All right, I move that we find for the city and the violation exists as alleged, and that we order the property owners to come into compliance by November 13th, 2025, or a fine of $50 per day per violation will be
I
imposed
think he
and
said
recorded.
100. He said 100.
Oh, 100. Let me backtrack. Yeah, I move that we find for the city and the violation exists as alleged, and that we order the property owners to come into compliance by November 13th, 2025, or a fine of $100 per day per violation will be imposed and recorded.
Second that, Ed Murphy.
All those in favor say aye.
Aye.
Any opposed? Why isn't $100 as opposed to normal?
Because she owns an apartment complex, and if it was an individual homeowner
Yeah.
that resides in the property, I just go $50 a day. But if you own an apartment house with 20 units in there, it's more of a commercial basis. So I tend to bump up to $100.
Makes sense.
Yeah. You know, I don't want to hurt an individual homeowner, so I usually go lightly with the $50 a day because they try to do their best to come into compliance.
Our next case, property address 1850 South Ocean Drive, 411. Owner, Catherine Webster, homestead exempted. Monica Webster, case number BE 2504-0210. Notice posted at the property on 7/11/25. Posted at 1 Eastboro Boulevard on 8/12/25.
Andrew Gebbia, building inspector for the city, presenting case and address as read. This property was cited for violation of the Florida Building Code 2023-105.1. Work illegally performed without obtaining the required permits in the following manner, but not limited to tile flooring. This case was opened on 4/29/25. The inspection report was mailed on 4/29/25. The Code Enforcement Board hearing was scheduled on 6/17/2025. I arrived at this property regarding another case, a kitchen remodel. There was possible work done beyond the scope of the original permit. There is an active permit for cabinets and electrical while I was there. I observed the tile floor installed. Checking records, there was no permit applied or issued for the tile floor. I have obtained photos from 2002 from the internet showing different tile and then carpet. Now it's just gray plank tile. I have been in contact with the owner, Monica Webster. She has a flooring permit applied for, BLD-GEN 2505-0607, which is awaiting client reply. The city is requesting the Code Enforcement Board to find that the violation exists and to grant the property owner 154 days to come into compliance or $50 a day thereafter.
I move that we fine for the city and the violation exists as alleged, and that we order the property owner to come into compliance by January 27, 2026, or a fine of $50 per day per violation will be imposed and recorded.
Seconded by Don Carney.
All those in favor say aye.
Aye.
Thank you.
Also on page 4, property address 700 Southeast 13th Street, owner 700 Southeast 13 Holdings LLC, case number BE 25050024. Notice posted at the property on 7/10/25, posted at 1 East Broad Boulevard on 8/12/25.
Andrew Gabbia, building inspector for the city, presenting case and address as read. This property was cited for violation of the Florida Building Code 2023-105.1, work illegally performed without obtaining the required permits in the following manner, but not limited to: new AC installation, windows, doors, wood deck, and trellis. This case was opened on 5/5/2025. The inspection report was mailed on 5/7/2025. Code enforcement hearing was scheduled on 6/17/2025. I arrived at this apartment complex on 5/7/2025. As I arrived, I observed a pressure-treated wood deck installation with trellis connected from the deck to the underside of the staircase. As I walked around the complex, I observed multiple windows changed out and 2 new doors changed out with new patch stucco around the doors. There was also a new AC installed, changed out. I received a phone call from the property management company for this complex. He stated they were in process of obtaining all the permits. They were working on to comply with the violations. There are permit applications submitted for all the stated violations. The city is requesting the Code Enforcement Board to come in to find that the violations exist and to grant the property owner 79 days to come into compliance or $100 a day thereafter.
I move that we fine for the city and the violation exists as alleged, and that we order the property owners to come into compliance by November 13, 2025, or a fine of, what was that again?
100.
100, or a
yeah.
fine of $100 per day per violation will be imposed and recorded.
I'll second.
All those in favor say aye.
Aye.
Any opposed?
Moving on to page 5 at the top, property address 7401 Northeast 19th Ave, owner Second Layer Equity LLC, case number BE 25050046. Notice posted at the property on 7/15/25, posted at 1 East Broad Boulevard, 8/12/25.
Andrew Gabbia, building inspector for the city, presenting case and address as read. This property was cited for violation of the Florida Building Code 2023-105.1, work illegally performed without obtaining the required permits in the following manner, but not limited to the demolition of a residential structure. This case was opened on 5/8/2025. The inspection report was mailed on 5/8/2025. The Code Enforcement Board hearing was scheduled on 6/17/2025. I have a related case on this property involving expired permits. I stopped by this property with the assistance of Building Inspector Russell Castile on 5/8/2025 to take photos for a special magistrate case that I have on 5/15/25. As I arrived, I observed the structure being demolished. I checked permits, and there is a permit.
I'm sorry, Andrew, before you keep going, we're having technical difficulties with showing the evidence for this case.
Okay.
For some reason,
Want
it's
me to
not
hold off?
coming up. Should we withdraw it?
Yeah, the pictures are demolished.
I mean, they're just not there, or?
Yeah. Okay, we're gonna recall it. We're gonna see if we can fix it, and then we'll just move on to the old business. Okay? Thank you.
So that's it for me. Yeah, but we need them up there. But we have the pictures.
Wait, isn't the next one on?
I'm on
27, 20.
Four. I think that's my last one.
If you can.
Yeah, that one we did already. That was
Oh, that was a C-word.
that was the first case this morning, I believe. Or at least second.
Senior Inspector Jorge Martinez at the bottom of page 6. Property address 6301 Northeast 20th Terrace. Owner Salvatore Capola. Case number BE 2403-0113. This case was first heard on 7/22/25 to comply by 8/26/25. One section at $50 per day. Order recorded, not complied. Notice posted at the property on 8/4/25. Posted at 1 Eastboro Boulevard on 8/12/25. This was a mandatory reappearance. And
Inspector Martinez updating case on behalf of the city. Case number and address as read. This case is not in compliance, and the city is requesting for the case to come back as a Massey.
Has the owner been in contact with you
No.
whatsoever?
No permits and no contact.
Page 7, property address, Senior Inspector Alexander Boris, property address 807 Southwest 14th Court, owner Lincoln Sports and Entertainment LLC, case number BE 2407-0006. Notice posted at the property, excuse me, on 8/4/2025. Notice posted at 1 Eastboro Boulevard on 8/12/25. This case was first heard on 3/25/25 to comply by 7/22/25. One section at $50 per day. Order recorded, not complied. There's one extension noted. This case was also a mandatory reappearance.
Alexander Labores, Building Inspector for the city, updating you case number and address as read. The property was cited for violation of Florida Building Code 2023, Section 105.1, work without permit. The violations remains at this time. Stated at the previous hearing, the board requested a mandatory reappearance. City does not support any additional extension, and it's requesting for the case to come back as a Massey hearing.
Has the property owner been in contact with you at all?
Not recently, not after the last hearing. We did reach out to, there's a permit application that's in process. We reached out to the permit applicant, left a voice message. I'm not aware they responded yet.
When was the application submitted and what's the status of it?
There's been multiple permits. We have a roof permit that was issued.
Issued?
For the re-roof, yes, for
Okay.
the re-roof. That's one component. We had some comments on the master permit for the interior alteration, because the part of the violation is that they removed their used aerial photographs show a chimney on this property, and then it just disappeared. And on their plans, there's no information regarding the chimney, so we requested additional information. What's the intent, or more information regarding the chimney. We haven't had any response to that yet.
So, but he's actually moving though, right? Sounds like you got a roof. You have a
Yes,
roof
they
issue.
have a roof permit.
All right.
Again, it was board requested, mandatory reappearance today. No one is here.
Page 8 at the
Thank
top. This is a hearing to impose fines.
Oh.
Property address 1410 Northwest 19th Ave. Owner Jose Villard Leonard Theodore. Case number BE 2404-0211. This case was first heard on 1/28/25 to comply by 3/25/25. One section at $50 per day. Order recorded, not complied. The city is requesting to impose fines of $1,700, which continues to accrue. Notice posted at the property on 8/1/25, posted at 1 Eastboro Boulevard on 8/12/25. There's one extension noted. The inspector said that there was no progress, and he's requested for the fines to be imposed.
I make a motion to impose the fine amount of $1,700.
Seconded.
All those in favor say aye.
Aye.
Any opposed?
Who seconded that?
Alex.
Thank you, Alex. Also on page 8, Senior Inspector Jose Sadagusti, property address 724 Northeast 16th Street, owner Lyons and Company LLC, case number BE 24090136. Notice posted at the property on 8/4/25, posted at 1 East Harbor Boulevard on 8/12/25. This case was first heard on 3/25/25 to comply by 7/22/25. One section at $50 per day, order recorded, not comply. The city is requesting to impose fines of $1,700, which continues to accrue.
Inspector Saragusti, on behalf of the city, updating the case as read. The case is not complied. The city is recommending for fines to be imposed.
Any communication?
With them, but they have permit awaiting client reply since April 23.
April?
April. For that one, we will impose a fine and
All right, motion to
for
impose,
this case.
Oh, sorry. Motion to impose the fine of $1,700.
Second.
All those in favor say aye.
Aye.
Any opposed?
Property address 1324 Northwest 5th Ave, case number BE 24060063, owner Senaran Eshwar Jr. Notice posted at the property on 8/1/25, posted at 1 East Borough Boulevard on 8/12/25. This case was first heard on 1/28/25 to comply by 3/25/25. One section at $50 per day, order recorded, not comply. The city is requesting to impose fines of $1,700, which continues to accrue. There are 2 extensions noted.
Inspector Saragusti, on behalf of the city, updating the case as read. With the owner, and he's working to comply the case. The city doesn't oppose 79 days extension and stop the fines.
Stop,
Yeah.
sorry, stop the fines?
Yes.
What's the reasoning behind your leniency relief?
No, he.
He has me.
It's
Just want to know.
incredible. He don't be in contract with me.
He has.
Yes, but he demolished another part of the property, not the part that is in the case. It's incredible. He demolished a room in the property that it was without permit,
Yeah.
but the case it was for another area that is still there in the property. He will demolish, but he need more time.
All right.
Okay.
For that one, 79 days extension and stop the fines, I think is correct.
Okay. Yeah, motion to stop the fines and provide a 79-day extension.
Seconded by Don Carney.
And all those in favor say aye.
Aye.
Any opposed?
Thank you.
Page 9, Senior Inspector Jorge Martinez, property address 930 Southwest 29th Street, A-B, case number BE 24070342. Owner, Zadquil Inc. Notice posted at the property on 8/4/25, posted at 1 East Borough Boulevard on 8/12/25. This case was first heard on 3/25/25 to comply by 7/22/25. One section at $50 per day, order recorded, not complied. The city is requested to impose fines of $1,700, which continues to accrue.
Inspector Martinez updating case on behalf of the city. Case number and address as read. Case is not in compliance. The city is requesting for fines to be imposed. No permit application. Okay. So I had contact with them last week. They called me. They said that they hired an engineer. The engineer came yesterday and confirmed that he was hired to get the permits.
So what do you recommend?
Well, I recommend that fines to be imposed.
So motion to impose the fines for $1,700?
Yes.
Okay.
I'll second. Alex Schneider, second. Yeah.
All those in favor say aye.
Aye.
Okay. Property address 1236 Northwest 16th Street. Owner 1236 Northwest 16th Street Land Trust. IAG Foundation, Inc. Trustee. Case number BE 24040187. Notice posted at the property on 8/1/25. Notice posted at 1 East Broward Boulevard on 8/12/25. This case was first heard on 9/24/24 to comply by 1/28/25. One section at $50 per day. Order recorded. Not complied. The city is requested to impose fines of $1,750, which continues to accrue. There are 2 extensions noted.
Inspector Martinez updating case on behalf of the city. Case number and address as read. Case is not in compliance. The city is requesting for fines to be imposed. There's no permit applications and no contact with the owner.
Was this supposed to be a tear down?
Let me check. No.
This is the one that has the mother-in-law's contact in the back?
No, this is a complete remodel. Oh, yes. I think yes. Yeah.
That was slated for a tear. The code people told me that it was slated for a tear down. And then they just started doing the work. Okay.
So I haven't had contact with them. Yeah.
Yeah, Mike, is there a reason that 1750? Should it be 1700?
There's an extra day involved than the other two. So it's 35 days, not 34 days.
Okay, motion.
But yeah, is there a reason why it's 35 days instead of 34 days, like the rest of them?
It was posted at the property 3 days earlier. Does that mean anything? No.
We stand corrected. It's a technical issue with our land-based system, Acela. So it actually should be 1,700 and not 1,750.
Motion to
and we will
impose.
try to correct it manually.
Do we have to correct it? We let it ride.
What do we can? I can
No,
just correct
no,
it right
it's
now.
1,700.
I can correct it right now. Motion to impose the fine of $1,700.
It
Second.
should be
All those in favor say aye.
1,700. That's what he meant said.
Yeah, it should be 1,700.
Yeah. At this time, the case that's on page 5, 741 Northeast 19th Ave, we are not able to show the pictures, the evidence. So at this time, the city is going to withdraw this case and bring it back in September. Yeah, well, we have to withdraw it now because we don't have the evidence to show. And if not, without evidence, we can't present the case to the board. Okay. So 741 Northeast 19th Ave, case BE 2505-0046, it's withdrawn. At this time, board, we would like to have all the cases listed on page, well, it's 10, should be, into the record as closed.
Motion to read the cases as listed on page 10 is closed. Oh.
Yeah, we did them. We did them all. Mm-hmm. Mm-hmm. Oh, did I get a motion for that one?
Yeah, I motion to enter the cases as read on page 10 is closed.
Thank you. And we have the minutes from when, Yvette? July?
Motion to...
Yvette, minutes are from July? From July's hearing?
My motion to approve the minutes from July's hearing.
Thank you. And for the record, Mr. Pujols, can you state what time you came in today? 10 o'clock? Okay, thank you. Is there any business for the city? Board? No, not at this time. Okay. Noted. At this time, this concludes our August 26, 2025 Code Enforcement Board hearing. Thank you.